guys, welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. So let's jump back into some other cases besides the Nancy Guthrie case. While it's very important, because every case is important, I want to kind of dive back into stuff that really does need some coverage. Obviously, I want to go back, continue to get through this, the closings and that sort of stuff with Tommy Zeigler. And later this week, I'm hoping to do some stuff on Summer and Michael Vaughn. You know, lots of stuff that I need to cover. And again, you guys can always drop me a comment in the community tab, send me an email, let me know what you would like to see on the channel. But we're going to jump right into these. Now, the actual closing arguments is a 52-page document, it looks like. That one I have requested to view, and I was hoping by today I would have access to it, and I don't. So what I'm going to go through is a couple of the exhibits, because you know, the two that kind of make more sense at this point. A few of them, I've been kind of going through them as we do the videos, as far as time's concerned, so it's kind of hard for me to look ahead. And there's a number of them that are excerpts from transcripts. So I'm not going to go through those because they don't make a lot of sense, you know, without the context. And maybe once we get the defense's closing argument, that'll make a lot more sense. And then I'd be more than happy to go back and we can check those out for sure. And again, the transcripts, you know, are long, as obviously, because the trial from 1976 is listed as an exhibit. There's snippets from that, and there's also, of course, from the evidentiary hearing, and that alone is like 1,003 pages long. So yeah, and without context, it's really hard to, you know, jump from, you know, one page to the other. So it just makes more sense for me to do the stuff that you know, kind of summarizes what the defense is after, and, you know, in addition to their closing, you know, arguments. All right, and of course, here is the Orange County Clerk of Court's website. I do have it scroll down here, but this one is, of course, there's the top there for William Thomas Zeigler Jr. Still open. We have not had a decision from the judge just yet, from Judge Marquise. I keep hoping that it'll happen, but there was a posting done. Let me see if I could pull this up here just a bit. There was a posting done. They were looking for further written briefing information. So we will get to that once we get through all of these pages, and it would be totally fine with me if we don't even get through all these before there's a decision made, because I don't know, I'm like you guys, I just want Tommy to get his, you know, his justice, and to have a ability to hopefully have his case reheard. And sadly, it's just been a waiting game for Tommy. So we did read in the last video, which was super long, the state's memorandum of law, which was the post-evidentiary hearing closing argument, and as you can see, that was 61 pages. So this is the notice of filing exhibit A to defendant's written closing argument. And this makes me worry because I haven't been through these myself before I'm reading it with you guys. And I'm wondering if that 52 pages is the actual closing argument. And I may see if I can get a hold of it this week. I'm going to see what I can do in that. But here we go. Comes now the defendant, William Thomas Zeigler, by and through his undersigned counsel, and hereby gives notice of filing the attached Exhibit A to defendant's written closing argument. Of course, it was signed by Ralph Hadley and his team here, and that was the team that we spoke about during his evidentiary hearing that totally was there for Tommy through the evidentiary hearing, and all of them are exceptional attorneys. They, you know, I got to speak with a couple of them, and I really hope that they have made a difference for Tommy. And of course, Ralph Hadley, who has been, you know, with Tommy from the get-go. So there's a certificate of service. I hereby certify that on February 5th, 2026, the foregoing document was electronically filed using Florida Court's e-filing portal, which will send the foregoing document by email to all counsel of record. Of course, that was signed by Ralph Hadley, and it says Exhibit A. Let's see. After a review of all of the evidence and exhibits presented at the post-conviction evidentiary hearing on Mr. Zeigler's motion to set aside convictions based on newly discovered evidence, and in light of the record at trial and on appeal, this court finds as follows. Proposed findings of fact. 1. The newly discovered evidence involved comprehensive testing conducted over the course of over a year by independent analysts. HRing TR 173, 18 through 23. The analysts collected 232 samples for testing from 43 items. 47 samples alone were from Mr. Zeigler's clothing. HRG 206, 24 through 27-1. I'm going to assume that references some sort of document or the evidence at hand here. If anybody knows, please let me know in the comments. The primary analysis, Kristen Hardy Connell of Forensic and Analytical Lab, Crime Lab, testified at the hearing. And of course, there's another number. This court finds that testimony by Ms. Hardy Connell at FACL was credible. 2. The new testing was collaborative. The state was involved in weekly and bi-weekly communications regarding decisions to test items of evidence. The state had the opportunity to request additional testing on all items. The defense paid for all testing, including testing requested by the state. 3. Mr. Kenton Wong examined items to be tested and, along with Ms. Hardy Connell, determined where the samples should be taken. Mr. Wong testified at the hearing. This court finds that testimony by Mr. Wong was credible. 4. Mr. Zeigler's counsel followed the advice of Mr. Wong and Ms. Connell in selecting items for testing. 5. Ms. Hardy Connell and Mr. Wong were instructed by Mr. Zeigler's counsel to perform robust testing. 6. The state requested that FACL avoid testing items when the testing would fully consume a sample and thus prevent a future laboratory from retesting the same sample. And that makes sense because they don't want to use up everything. I mean, they're trying, I guess pretty much at this point, they are kind of putting all their cards on the table, but at the same time, they don't want to put every single piece of potential possible retesting on there because, you know, even though we seem to be in the last ditch possible effort to, basically get Tommy off death row and exonerate him or get him a new hearing, you don't want to use up every last possible, out for him if he can be proved innocent. All right, Perry Edwards. 7. Perry Edwards was beaten severely with 14 blows as well as shot. His death involved a prolonged struggle about which the jury heard extensive testimony. And of course, these are all going to be referencing here, it looks like, the trials. And of course, it's referencing Zeigler versus State, and then 402 Southern 2D, 365, 367, and that's Florida 1981. So I'm probably going to skip most of these numbers, although I may go through some of the sightings from the, from his previous trial there. 8. At trial, the state, through cross-examination, questioning, and through its closing argument, strongly implied that Mr. Zeigler beat Perry Edwards. 9. The attack on Perry Edwards would have produced blood spatter as well as significant freely flowing blood stains. Mr. Richard Eichenblum conducted a blood stain analysis and testified at the hearing. This court finds that testimony by Mr. Eichenblum was credible. 10. The perpetrator of Perry Edwards' attack would have gotten a back spatter on their clothing. 11. Mr. Zeigler had none of Perry Edwards' blood on his clothing. 12. The newly discovered evidence supports the inference that Mr. Zeigler did not struggle with Perry Edwards. 13. The newly discovered evidence supports the inference that Mr. Zeigler did not kill Perry Edwards. 14. As the state conceded, the newly discovered evidence does not support the state's theory advanced at trial that Mr. Zeigler struggled with Perry Edwards. 15. Mr. Zeigler's shoes had two samples in which Charles Mays was identified as the major contributor, and Perry Edwards was identified as being an actual or potential minor DNA contributor. The expert testimony adduced at the hearing indicated that it is not possible to reach a conclusion as to whether this DNA, if it came from Mr. Edwards, was from Mr. Edwards' blood or other genetic material, or as to the sequence of the sample's disposition. The court finds that the limited amount of DNA, even potentially contributed by Mr. Edwards on Mr. Zeigler's shoes, and the absence of such DNA anywhere on Mr. Zeigler's clothing, supports the inference that Mr. Zeigler did not administer the beatings that produced Mr. Edwards' multiple head lacerations and did not repeatedly shoot Mr. Edwards. 16. Perry Edwards' blood was found on Charlie Mays' pants. The blood got onto Charlie Mays' pants while still wet, and thus Charlie Mays was present around the time Perry Edwards was killed. 17. The newly discovered evidence supports the inference that Charles Mays was present at the scene when Perry Edwards' blood was wet. That's big important. Eunice Zeigler. 18. The attack on Eunice Zeigler produced back spatter. 19. The perpetrator of Eunice Zeigler's attack would likely have gotten back spatter on their clothing. 20. The newly discovered evidence shows that Mr. Zeigler's clothing had no blood from Eunice Zeigler. 21. Blood on Eunice Zeigler's shirt and inside her coat were deposited when Eunice Zeigler's coat was open. And then they're referencing here the photo of Eunice. Eunice Zeigler was repositioned after her death and her coat was closed. And when I recall from the state's closing, they don't agree with that. And I totally agree with that it was moved. And I agree that she was moved. 22. In 1976, the jury heard that Eunice Zeigler's coat was likely repositioned. There you go. 23. None of Mr. Zeigler's DNA was found on Eunice Zeigler's coat. 24. Charles Mays' DNA was the only known DNA profile that could not be excluded as a DNA contributor in the places the killer likely would have touched on Eunice Zeigler's coat. Virginia Edwards. 25. The attack on Virginia Edwards would likely have produced back spatter. 26. The perpetrator of Virginia Edwards' attack would likely have gotten back spatter on their clothing. 27. The newly discovered evidence shows Mr. Zeigler's clothing had no blood from Virginia Edwards. How could he have no blood on him from his wife and his in-laws if he did it, he would have been covered in their blood. And this whole raincoat theory that the state seems to still like to be on, even though they never found it, so ridiculous. Mr. Zeigler. 28. Mr. Zeigler's pants have Mr. Zeigler's blood spatter on front and back. And they're referencing, it looks like the photograph here. It is very unlikely that such spatter could have come from Mr. Zeigler's gunshot entry or exit wounds, which were his only open wounds. 29. The blood spatter suggests that Mr. Zeigler was hit in the abdomen after he was shot, which supports the inference that Mr. Zeigler was struggling with one or more people when he was shot, and he did not shoot himself. 30. Mr. Zeigler is right-handed and was shot in the right side of his abdomen by a larger, more powerful gun than any other weapons nearby weapons. 31. Mr. Zeigler's gunshot wound through the right side of his abdomen and back is inconsistent with a self-inflicted wound by a right-handed person. 32. The newly discovered evidence, viewed cumulatively with the existing evidence, gives rise to reasonable doubt as to whether Mr. Zeigler shot himself or was shot by another person. 33. Mr. Zeigler's trial testimony about swinging and firing a pistol at assailants is consistent with the newly discovered evidence. 34. Mr. Zeigler is of advanced age and poor health. Sequence of murders. 35. At trial, the jury heard that the evidence proved the sequence of killings and assaults. Eunice Zeigler, then Perry Edwards, then Virginia Edwards, then later, after a trip to the Orange Grove with multiple people, Charles Mays. 36. At the evidentiary hearing, the state's expert testified that based on the DNA evidence, it was not possible to determine the sequence in which the murders occurred. Investigation. 37. The investigators failed to maintain a contamination sheet, a crime scene log required by their law enforcement procedure and which they knew should be kept. Sloppy police work. Mr. Imbroom Garcia testified at the hearing with respect to shortcomings in the investigation. This court finds that Mr. Garcia's testimony was credible. 38. Investigators failed to properly subtype blood found at and near the crime scene. 39. There is evidence not heard by the jury that investigators in this case attempted to coach witnesses. In April 1976, Mr. John Jellison provided investigator Bachman with an eyewitness account of observing police at the scene of the murders and hearing gunshots. Mr. Jellison was not called to testify at trial and did not hear further from the state. A motion to vacate conviction at 1418, so they're of course referencing the other documents and hearings there. Mr. Bachman attempted to have Mr. Jellison change his story to fit the state's theory. Mr. Jellison testified at the hearing by deposition. This court finds that Mr. John Jellison's testimony was credible. You remember, Mr. Jellison is the one who was staying at the hotel with his family, and they're like, if you could change your story, you get a free trip to Florida. Ha ha. Yeah, alright, dude. 40. The testimony of Felton Thomas by deposition was submitted at the hearing. Mr. Thomas recanted his trial testimony about Mr. Zeigler handing him a gun at the orange groves and shooting the weapon. This court finds that Mr. Thomas's testimony undermined the credibility of Mr. Thomas's testimony at trial, in which Mr. Thomas previously testified that Mr. Zeigler had him shoot out of the vehicle's window, inferring that the purpose of the trip was for Mr. Thomas to leave his fingerprints on one of the weapons. Proposed conclusions of law. 41. To obtain post-conviction relief based on newly discovered evidence, Mr. Zeigler must show the new evidence could not have been known by the parties at the time of the trial or through defendant's diligence, and the new evidence would probably produce an acquittal on retrial. Johnson v. State, 27 Southern 3D, 11 and 18, Florida 2010. Jones v. State, Jones 2, 709 Southern 2D, 512, 521, Florida 1998. 42. The court's analysis is cumulative, as the court must evaluate the newly discovered evidence in the context of all evidence introduced at trial, as well as evidence previously raised yet barred. Roberts v. State, Swafford v. State, and that's 2002, and Florida 2013. 43. The newly discovered DNA results indicate that blood from Nene Zeigler, Virginia Edwards, and Perry Edwards was not found on Mr. Zeigler, where a jury would reasonably expect it, being given the nature of the crimes. See Hilden v. State, and that's Florida 2014. 44. Investigator Bachman improperly determined that Mr. Jellison would not receive a follow-up interview when his testimony contradicted Bachman's account of events. The totality of the evidence would allow the jury to conclude that the state failed to properly investigate this crime scene, and thus the evidence against Mr. Zeigler is weak. See Hilden, Southern 3D at 1180. Yeah, so like the law enforcement at the time, and that's even before it hit, the judge. I mean, they were just like, yeah, we're not going to do all this. Sloppy police work, and dare I say, corruption. 45. The court holds that it must consider Felton Thomas's 2025 deposition testimony in evaluating the cumulative evidence in this case. As the Florida Supreme Court explained in Hilden in 2014, quote, this court held in Lightbourne and more recently in Swafford, a post-conviction court, must even consider testimony that was previously excluded as procedurally barred or presented in another post-conviction proceeding in determining if there is a probability of an acquittal, unquote. Hilden, and that is also Roberts v. State, Florida 2002. 46. The court concludes as a matter of law that prior decisions in this matter do not bar relief. And they're saying compare 2005, 419, 2005, order denying motion to vacate at 15. 47. The court finds that there are extensive contradictions between the newly discovered evidence and the evidence the jury heard at trial. The court concludes as a matter of law that these contradictions create reasonable doubt as to Mr. Zeigler's guilt. See Hilden. They can quote back to Hilden. 48. The court finds that the state made multiple concessions regarding contradictory evidence the jury heard at trial. The court concludes as a matter of law that these contradictions create reasonable doubt as to Mr. Zeigler's guilt. 49. Mr. Zeigler met his burden at the evidentiary hearing and showed that the totality of the evidence against him is weak, and that at a new trial a jury would probably find reasonable doubt as to his guilt. 50. The court concludes as a matter of law that Mr. Zeigler poses no threat of harm and is to be granted immediate release from custody. State versus Blair, that's Florida 2010. State of Florida versus William Thomas Zeigler Jr. Expert report of Richard Eichenblum. He is the Independent Forensic Services, LLC. Looks like he's out of New Mexico. I think I heard that before. All right. So here is his report. At first, he has his qualifications. I believe that's required, obviously, for the court. So we're not going to really read any of that. There's his qualifications. If you want to freeze it and read it, if you're interested. It looks like he is being compensated, just for those that are curious. $200 per hour, as far as that's concerned, because obviously nobody works for free. And then the background, he does go through the background here. William Thomas Zeigler. T. Zeigler was convicted of 4 murders that were committed at the furniture store that he owned on December 24th, 1975. The victims were his wife, Eunice Zeigler, E. Zeigler, father-in-law, Perry Edwards, P. Edwards, mother-in-law, Virginia Edwards, V. Edwards, and another man, Charlie Mays, C. Mays. I think he puts them that way because that's how he refers to them in his report. E. Zeigler and V. Edwards were both killed by close-range gunshots to their temples. P. Edwards was killed by blunt force trauma and close-range gunshots. Mays was killed by gunshots and blunt force trauma. DNA evidence had not yet been used in a criminal matter at the time of T. Zeigler's conviction. In 2001, T. Zeigler conducted limited DNA testing of certain items of evidence. The results of that DNA testing showed that T. Zeigler did not have any of P. Edwards' blood on his clothing. T. Zeigler moved to set aside his conviction based on this DNA evidence, but his motion was denied. T. Zeigler and the state attorney's office jointly moved in 2021 to release the evidence in T. Zeigler's case for comprehensive DNA testing. The motion was approved, and the evidence in T. Zeigler's case was sent to the Forensic and Analytical Crime Lab, FACL, for DNA testing. Okay, so let's move on. All right, here's his summary of conclusions. I have reached the following conclusions based on my investigation and analysis of the materials provided. Should the new information become available, I reserve the right to revise my report and conclusions. 1. The absence of P. Edwards' DNA on T. Zeigler's shirt, pants, or socks supports the hypothesis that T. Zeigler did not shoot or beat P. Edwards. P. Edwards shed large amounts of blood throughout the crime scene, and his blood is present in substantial quantities on E. Zeigler, C. Mays, and on a pillow located near the body of V. Edwards. I agree with the expert for the state, David Baer, that P. Edwards' murder would have resulted in a large quantity of transferred blood onto P. Edwards' killer, and that the blood evidence would remain detectable today. T. Zeigler's clothing was tested extremely comprehensively. None of P. Edwards' blood was found to be present, other than as a minor contributor and possible minor contributor of DNA, and 2 bloodstains on T. Zeigler's shoes. These findings are inconsistent with T. Zeigler murdering P. Edwards. 2. From sample 34 to A, from the left shoe of T. Zeigler, a mixed profile was obtained which matched the DNA profiles of C. Mays and P. Edwards. A mixed profile was also obtained from the side of the rubber instep of T. Zeigler's right shoe, sample 34 1D, with limited evidence that P. Edwards was a minor contributor to the sample. Neither finding, however, is consistent with T. Zeigler murdering P. Edwards. P. Edwards was a minor contributor of DNA in both samples, which are the only samples where any of P. Edwards' DNA was found to be present on T. Zeigler's clothing. C. Mays was a major donor of DNA in both samples, with P. Edwards' DNA only detected as a minor contributor. This is more consistent with incidental contact between the shoes and P. Edwards' DNA than it is with T. Zeigler shooting P. Edwards repeatedly and beating him to death. For instance, it is possible that clotted blood and or tissue of P. Edwards was transferred in small quantities onto the shoes during a fight between T. Zeigler and C. Mays, or through T. Zeigler's movement in and around the crime scene. Clotted blood contains fewer white blood cells, which could explain why C. Mays is the major donor in the samples. 3. The absence of V. Edwards and E. Zeigler's DNA on T. Zeigler's clothing supports the hypothesis that T. Zeigler did not shoot V. Edwards or T. Zeigler either. Both were killed in a manner that would have produced a substantial quantity of backspattered blood onto the perpetrator or perpetrators. No such blood was found on the clothing of T. Zeigler. 4. The state has argued that these results could still be consistent with T. Zeigler's guilt. I disagree with this conclusion. There is no evidence that T. Zeigler wore a raincoat on the night of the murders. Further, the presence of C. Mays' blood on T. Zeigler supports the premise that T. Zeigler was not wearing a raincoat at the time he was involved in an altercation with C. Mays. There is no support for the hypothesis that T. Zeigler wore a raincoat for the murders of P. Edwards, V. Edwards, and E. Zeigler, but removed it prior to murdering C. Mays, given that the state of blood testing at the time would not have been able to identify with accuracy which victim's blood was on his clothing. Further, even if T. Zeigler had worn a raincoat, it is likely that blood spatters would have landed on his pants and socks and would also have gotten inside the sleeve cuffs of the raincoat. A raincoat would also likely have been dislodged during a violent struggle with P. Edwards, exposing any otherwise shielded clothing to the blood and the DNA transfer. Yet no DNA from P. Edwards, V. Edwards, or E. Zeigler was found in any of these locations, despite extensive testing. 5. The DNA of P. Edwards on C. Mays' pants is inconsistent with the hypothesis that C. Mays arrived at the store after P. Edwards was killed. 6. The whole area around samples 89H and 89K from the coat of E. Zeigler, which is item 89, has a number of circular bloodstains which are likely caused by an impact in blood of P. Edwards. Given that a number of bloodstains are smaller than 2 mm increases the likelihood that this area is actually a pattern of backspatter from P. Edwards, maybe combined with blunt force impact spatter. 7. E. Zeigler appears to have been staged at one point. It is possible someone put her right hand in her pocket. Based on the DNA results obtained from 89N, there is some support for the hypothesis that C. Mays put the hand in the right pocket, leaving some of his DNA. See, yeah, it doesn't make any sense that she would have had her hand in her pocket. I mean, of course, there's other things about it, but that whole pocket thing is just like, she didn't have her hand in her pocket. 8. During Y chromosomal DNA testing of sample 89D, a partial match was obtained with C. Mays. This result supports the hypothesis that C. Mays, with blood of E. Zeigler on his hands, touched her on the left cuff of her coat, item 89. 9. Test results indicate that Mays may have left his DNA in 5 different locations on the coat of E. Zeigler: 89N, right pocket; 89D, blood left cuff; 89G, blood back right lapel; 89O, blood interior and exterior cuff; and 89P, interior and exterior right cuff. This is not likely explained by contamination and is more consistent with Mays or another unknown individual contributing meaningful amounts of DNA to the very locations on E. Zeigler's clothing that were likely to be touched by her killer. No DNA from T. Zeigler was found on any of these or any other locations on E. Zeigler's clothing. 10. The likely touch DNA of C. Mays is present in the samples from E. Zeigler's coat, 89, which supports the hypothesis that he was not yet wounded at the time he transferred his DNA onto E. Zeigler's clothing. Mays would likely have died quickly from his wounds, and it does not appear likely that he would have been manipulating E. Zeigler's clothing after being shot and beaten. Touch DNA of C. Mays on E. Zeigler's coat would accordingly support a scenario where Mays manipulated the body of E. Zeigler before the fight with T. Zeigler. 11. Bloodstains were observed on the bottom, side, and top of the left shoe. Item 90 of E. Zeigler. DNA in the sample to the left shoe sole matches P. Edwards. The passive drops of blood and or blood spatter on the sole and side of the left shoe support the hypothesis that the shoe was not standing on the floor where the spatter and or passive drop hit it. This could support a scenario where the sole of the left shoe, 90, was tilted toward P. Edwards when he was beaten or when he was dripping blood from an injury. 12. The blood of P. Edwards on the toe, item 90-3, of E. Zeigler's sock supports a scenario in which E. Zeigler's shoe came off during the incident and blood dripped and or spattered on the sock. 13. Blood of P. Edwards was detected on the toe area of the sock, 93A. This could be spatter given the size, shape, and way it was embedded in the sock, but even the transfer of liquid blood alone supports a scenario of staging of E. Zeigler. 14. Given the amount of blood spatter of P. Edwards on E. Zeigler's clothing, there is a support for the hypothesis that this was transferred during the altercation of a perpetrator with P. Edwards. If P. Edwards was involved in an altercation with the perpetrator at the time when P. Edwards and E. Zeigler were alive, it would be difficult for a single perpetrator to control all three victims, especially when one or two victims are actively resisting. 15. DNA from some blood spatter on the pants of T. Zeigler, item 31, matches the profile of himself, supporting a hypothesis that force was applied on liquid blood of T. Zeigler when he was already injured. If the only bleeding injury of T. Zeigler was the gunshot wound to his right side, it would support a scenario where the perpetrator or perpetrators hit T. Zeigler on the bleeding injury while blood was still liquid. 16. There would be no reason for T. Zeigler to beat himself in his own blood when he is already covered in blood spatter of C. Mays. Any time where forensic DNA did not exist makes a scenario like this not likely. 17. Blood spatter of T. Zeigler could have been transferred to attackers. 18. The bloodstain analysis and DNA results support the hypothesis that P. Edwards died before C. Mays got injured. 19. Although the statistics are low, F. Thomas could have donated DNA to sample 5C. If F. Thomas donated DNA to the jacket of V. Edwards, it would refute his statement that he was never in the store. So we're going to stop there for now and hope that I will get this closing argument on the next couple days, and we will make more sense of the transcript portions. But I'm definitely game to go back through some of those. So with that said, let me know your thoughts and opinions in the comments. And I hope you guys have a great rest of the day. And most of all, stay safe.